2. An order of this Honorable Court striking out grounds 2 of the petition and all associated facts contained in paragraph 20, Roman 2, 33 to 78 of the petition for being incompetent. 3. An order of this Honorable Court striking out paragraphs 2, 20, Roman 2, 33 to 78 of the petition for not being in support of any valid ground in the petition. 4. An order of this Honorable Court striking out paragraph 21 to 27, 29 to 100 of the petition for being non-specific, lacking in clarity, generic, nebulous, vague, speculative, and gold digging in contravention of the first schedule to the Electoral Act 2020. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act, and variously argued that the paragraphs of the petition which they have listed are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing, they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous, defeated because the petition, the argument that the petition are vague, paragraphs of the petition are vague and nebulous, is defeated because the petitioners have indicated in the petition that they shall be relying on spreadsheets and forensic/expert evidence to prove the avowed facts. The petitioners have particularly argued that in paragraph 61, 65, 67, 69, 70, 71, 72, 73, 83, and 100 of the petition, they have pleaded the said spreadsheets and forensic reports by incorporation or reference, and that this means that the said documents have not only been incorporated but have been sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed and Ipiazu and Oti, Ogu and Ekweremadu, Ojuku and Eradua, PDP and INEC and others, and Soga and Iguede, and all other cases cited by the respondents are not the same with the facts of this petition, because documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2 of the first schedule to the Electoral Act 2022 and argue that the respondents have joined issues with the petitioners on those paragraphs, and having failed to seek for further particulars, they must be taken to have understood the said paragraph. They relied on some cases which are reproduced here. Now, resolution. I have carefully considered the submissions of the parties and the judicial authorities cited. It is trite that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. The general principle of law is that such pleadings must sufficiently and clarify the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary of the case he is to meet and to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts. It is therefore a safeguard against element of surprise. See Shodipo versus Lemini Kane, Odom and others versus PDP and others, Alassane and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2022. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based and the relief sought by the petitioners, unquote. Subparagraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019. Subject to such modification, ambiguous means that each averment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the averments in the petition in ascertaining the allegations being made in the petition. In particular, paragraph 4 sub 1 sub D relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the arguments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general its defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded and in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offences in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub d of the first schedule, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the arguments in the pleading must not be general, it must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is non-starter. I have nothing to add to this statement of law as advanced above and adopted as unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC, Supra, that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's petition was in the instant case, unquote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraph 4 sub 1 sub d of the first schedule to the Electoral Act 2022 on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 sub 1 and sub 2 of the first schedule to the Electoral Act 2022 relating to further particulars on the other hand, shows that whilst in cases such as Abubakar versus Eradua and Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of arguments in an election petition should avail himself of the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act to seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, Belgore, and Ahmed, have specifically held that where arguments in the petition are grossly imprecise and generic, such arguments will be incomplete practices, but fail to specify the polling units or places where the irregularities or malpractices occurred, are bereft of material particulars, and such arguments are incompetent and liable to be stopped. As specifically stated in PDP and INEC, the petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such argument. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, and Ipiazu and Uti, and several others, and the mandatory requirements for stating material facts as provided in paragraph 4.1 first schedule, the same first schedule. On the IRF, in 18,088 polling units, the petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. In paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they alleged there were no elections. The incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, Alona and Plateau and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally encoded by the second respondent and how they were disfavored. In paragraph 83 of the petition, where the petitioners claim that the first respondents got the majority of local votes in the election, they did not state the majority of local votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on 8As to establish substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, the petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. To observe that in paragraph 79 of the petition, where the petitioners alleged corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practices, while standard of proof of non-compliance is from the balance of probabilities, that of corrupt practices is beyond reasonable doubt. See PDP, INEC, Mohammed, Wamako, Board of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2 to 3.21 of their submission, in opposition to the first respondent's objection, petitioners appear to have considered that is to prove the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has the first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as a winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, unquote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporating into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, the spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by Usafina, being the petitioners own their own if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Pagungumiju JCA, as it then was, now JSC, held in Udiaga and another was Omegara, as follows, and I quote, The argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to pinpoint in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints to which the respondents could reply in detail in their own pleadings. The appellants expected the respondents to reply only on the strength of his own case and not on the weakness of that of the respondent. Busari versus Abeokuta, Oyetola versus Adeleke, and Anazong, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of the party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others versus Abi. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units produced here. First respondent asked the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5 sub 1 and sub 2 on the other hand for being inconsistent. Conversely, the petitioner contend that the law allows them to plead conflicting facts insofar as they have claimed alternative relief. They referred to the alternative reliefs at pages 35 to 37 of the petition and relied on some cases which are reproducing, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition which I have reproduced at the beginning, reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Umaogu and others, this court, Ogun Women's Jesse, as he then was, held that, and I quote, in civil litigation, a friend hates of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance, and in the same breath claim that he won the election by petitioner may plead the same set of facts to ground alternative relief. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief, as the party must decide which relief is best supported by the evidence on it, unquote. See also on this metal construction was opponent for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition, which are reproduced here. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2027. They argued that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022. Joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by Section 77 sub 3 of the Electoral Act 2022. And since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the local standard to challenge the outcome of the presidential election. provision of Section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member. The second petitioner has provided for in Section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership of the second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. The first respondent in his motion of 19th of April 2023 and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election, the petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as the respondents to the petition. For that reason, the respondents have contended that this court lacks jurisdiction to obtain the petition as constitutional. They place reliance on JKD and INEC. Buhari and Obasanjo citations on the record. In opposition, however, petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in Section 133 of the challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing was not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate two or more petitions which are presented in relation to the same election or return. As of JKD and INEC, cited by the first respondent, is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar challenged the competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are: first respondent's motion filed reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act 2023. Second and third respondents' motion filed on the 13th of May 2023, seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for reply, as well as the witness statement on oath for failure to deny the fourth respondent's allegations. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply to the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply to their respective replies, or in the alternative the paragraph thereof, which they have seen. Within 5 days from the receipt of the respondent's reply, the petitioner's reply in answer to the new issues of fact. So, however, that A. The petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him. By the import of paragraph 16 sub 1a of the first schedule, the petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1a are, quote, new facts, grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. Told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issue in the plaintiff, and that does not bear the name of a new issue in law. The new issue arises where the plaintiff did not avert averment was introduced in the pleadings for the first time and therefore unique and novel to his claim, unquote. A careful examination of the petitioner's petition, the first, second and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies to the respondents' replies which were not contained in their petition. 17. Second part of 18, 22, 24 of the first respondent's reply are traversed of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraphs 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply, the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the petitioner's reply to the second and third respondent's reply in service to. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations of fourth respondents, which the fourth respondents have no opportunity to explain. Being in contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby stricken. And that indeed is the rulings on the respondents' objections, various objections.
Consideration the entire averments in the petition and determine the merit or otherwise of the petition in case of justice. At trial, the petitioners opened their case with tendering from the bar several certified copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the stage of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents to file separate addresses on their objections along with their final addresses. Proof of their petition: the petitioners called 13 witnesses who gave evidence as PW objections which they raised in the trial. So we shall now consider the respondents' objections to the competence of some of the petition witnesses and to the documents tendered by them during trial. To save time, we skip the addresses of counsel and go to the petition position. resolution of the respondent's objection to witnesses and documents contained in page 84 of the judgment. In the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath of those witnesses of the petitioners were not from what